Categories of law. What type of law are you dealing with? In this section, we're going to ask the question, what is the law about, and what type of behavior does it regulate? There are several different kinds of laws in different categories, which I want you to be aware of. There's substantive law and procedural law, there's criminal versus civil law, and there's constitutional law, statutory law, and administrative law. These, you'll see, will overlap at some points, and sometimes they'll be mutually exclusive. So let's look at a couple of these different terms. When asking what is the law about, the first question we want to ask is if it's substantive law or if it's procedural law. With substantive law, the content defines what can and can't be done legally. So, for example, it's going to regulate some sort of conduct, something that you can actually do or you can't do. A rule which says that there is no swimming in the lake is going to be a rule about conduct, and so therefore it will be under the category of substantive law. Procedural law, on the other hand, actually talks about the procedures that are used to conduct the law. And so a procedural law would be something which talks about the process. For example, in order to file for a marriage certificate, you need to bring in the birth certificates of both parties. This would be a procedural law because it establishes some part of procedure. So here's how you want to look at laws. Laws generally are rules of either conduct or procedure, and they're either formally recognized as binding, they're agreed to, or they're enforced by a controlling authority. So you can go down the pyramid any one of the ways you want. You can go a rule of conduct that is agreed to, a rule of conduct that is enforced by a controlling authority, or you can say that this law is a rule of procedure which is formally binding, or a rule of procedure which is agreed to. So what type of behavior does the law regulate? We're going to talk about two different flavors of law, criminal law and civil law. Criminal law is probably the most well known because this is the type of law which TV really gets its hands on and we hear the most about. These are the types of things you see on the cop shows on TV and they get the most notoriety in the press. Criminal law prohibits specific behaviors. And I want you to remember that criminal law has everything to do with crimes. Crimes are against the state. They're not necessarily against other people. And so they're going to be prosecuted by the state. Whenever you see a lawsuit which says the people versus Randy Jones, the people versus O.J. Simpson, or whatever it is, you know that it's prosecuted by the state, and that would be a criminal offense which is being prosecuted. The remedy for this would be incarceration, jail time, or it's going to be a fine. On the other hand, we have civil law. Civil law is actually a much broader world of law, but it's just not as celebrated, you might say. It regulates interactions between two different people. So instead of between the state and you breaking a law that the state has been put in place, it's actually between two different individuals. So you're going to see the court resolving a difference between a plaintiff and a defendant. You're not going to see a prosecutor here because there's no state involved. Instead, there are just two parties, and so it's often last name versus last name, as in Smith versus Barney. In civil law, we regulate interactions called torts. And unlike crimes, torts have a very different remedy. You can't put people in jail on a civil matter. The remedy would be damages, restitution, and specific performance. And we'll talk about all of those in a minute. So let's talk about these civil remedies. Damages is pretty simple. Damages just means money. Why it is called damage, I'm not exactly sure, but what this means is that the person who has been damaged is going to be compensated monetarily for their particular loss. Restitution is when you put the wronged party back into the place as if nothing has ever happened. So you make them whole in a way. So if the person lost out on being able to attend a certain conference, then you're able to somehow allow them to attend that conference. You know, they miss a flight, you get them on another flight, some way to put them back in the position that they started out in and to make things right again the same way that they were. A good example of this would be, for example, somebody's bike is stolen. Well, replacing the bike with the same bike that they had before would be as if to make it like the bike was never stolen in the first place. The third is specific performance. Specific performance says you have to do whatever is going to make the original party that was wronged do whatever you agreed to do. And so, for example, saying to a party that was wronged, you were supposed to paint my fence, and you broke the contract and you didn't paint my fence. And so specific performance is going to be a judicial order which says you have to go and paint the person's fence. You have to do what you specifically contracted to do in the beginning, and you have to go along with that. So why would you choose one remedy over the other? Patty Plaintiff spent a week baking and decorating a wedding cake for her client. On the day of the wedding, she stepped outside of her house with the cake, and her neighbor, Dustin Defendant, sprayed water all over Patty, ruining the cake. Plaintiff wins. In this case, let's be the judge and think about what type of remedy might be best to compensate the plaintiff for her loss. Patty is out a week baking, she made this spectacular cake, and she stepped outside and she was sprayed all over the place with with water. So what are we going to give her in order to make her right again? Well, we have our three options. We have damages, we have restitution, and we have specific performance. Let's go with the bottom one first. Specific performance would say that Dustin has to do whatever it is that he agreed to do. Well, Dustin really didn't have any agreement here, and there's nothing that he can do, really, to perform in this matter. We don't know if Dustin's a baker, but we're assuming that he doesn't bake or decorate on the same level as Patty Plaintiff, and so that one's probably going to be out. That leaves restitution and damages. Could restitution be an appropriate remedy? Restitution, remember, puts the plaintiff back into a position as if this had never happened. So the question is, can Dustin Defendant do that? Well, let's see. Can Dustin Defendant somehow make it so that Patty has her cake back and her week back after ruining it? Not likely. Very difficult to do, since Patty was the one who baked the cake herself, and she likely can't get the time or materials back for doing that, and it's not like going to the store and going to Target and purchasing a new bike for her. This is something she handmade that probably had a very specific client in mind, and she's probably going to miss the deadline to deliver her cake as well. So that's probably not going to work. So that leaves us with damages. Would Patty be able to be compensated by Dustin for the cost of the cake, or the cost that her client would have paid for that cake? Very possibly. So damages in this case would probably be the best remedy. Famous painter Darla Defendant promised Polly Plaintiff that she would paint a mural in Polly's house for $2,000. Darla started painting, but then decided to give up halfway through and write a novel. Polly is left with a half-painted mural. Plaintiff wins. So we go back to our three remedies: damages, restitution, and specific performance. In this case, Darla left Polly with a half-finished painting. Could we use damages to compensate Polly? Possibly. We could give her $2,000 back and fine Darla for that. But maybe that wouldn't be the best remedy, which would actually make Polly the most satisfied. How about restitution? Would we be able to put Polly back into the same where she started, with some sort of agreement that she was going to get a special mural from Darla? That's kind of hard. In this case, the best remedy is most likely specific performance. Darla said she was going to create a mural. Polly's paying $2,000 for that mural, so I'm guessing that Darla is a pretty good artist, and there aren't a whole lot of artists that could probably take her place in this instance. So a judge ordering Darla to finish what she started and completing the painting, because no one else could do it the way Darla can, might be an appropriate remedy here. Peter Plaintiff sues David Defendant for backing into his car and wrecking it. plaintiff wins. Damages, well, he could get money out of it. He could just go in and ask for money to fix the car and that be the end of it. Restitution, sure. David defendant might be able to fix the car, or he might have a sister who's a mechanic who can make it so that plaintiff is back and made whole in the same way he was before he started. Specific performance, I don't really see it here. Let me know if you can think of something for that. But because there was no agreement between the two, and there's nothing positive which David defendant was offering or did, then I would probably rule out this remedy here. Here's our criminal versus civil law matrix. Criminal law has crimes, while civil law has torts. The action is brought by the state or the government in criminal law, while the action is brought by an individual or multiple individuals in civil law. So you have a prosecutor in criminal law versus a plaintiff in civil law. You have defendants in both. And then the remedy, which we just spoke about, where we have criminal law, incarceration or fine, and in civil law we have damages, restitution, and specific performance. Really, when you're thinking about what type of lawsuit to bring, really you want to consider the desired outcome of the party that's bringing the action. What do you want to have happen? Now that you know the differences between the remedies, you know that criminal law can result in incarceration and fine, and civil law can result in damages, specific performance, and restitution. Bringing a lawsuit or asking a prosecutor to file a lawsuit could mean the difference in how the case is going to end up. Oftentimes, litigants think about what is the thing that they want to have happen. Is there a criminal that they want to put behind bars? Or perhaps is there money that they want to get out of something? Sometimes you have two different cases going on at the same time, one in the criminal courts and one in the civil courts, which arise out of the exact same matter. You can think about this, for example, in a murder case, where the prosecutor might be bringing a criminal law charge for murder in the first degree, while in civil law, the family of the murdered individual is bringing a lawsuit for wrongful death and asking for damages, because I don't think specific performance or restitution would work in this particular situation. These cases can run parallel, and it really depends on what the goal of the party bringing the action is.